Okay, good morning, ladies and gentlemen. I open here the hearing on preliminary objections in the case of Commerce Group Corporation and San Sebastian Gold Mines claimants versus the Republic of El Salvador respondent in exit case number ARB/09/17. I may first introduce the tribunal. On my right-hand side is Dr. Pereira Naon. On my left-hand side is Christopher Thomas. I'm Albert-Jan Vandenberg, and we have a secretary of the tribunal, who is Marco Montañez Ruimayor. It is a good custom that parties also introduce their team, and I would like to invite the claimants, plural, just this side, is that true? To introduce that team.
Thank you very much, sir. My name is John Makalak. I'm the representing Commerce Group Corp and San Sebastian Gold Mine, Inc. To my immediate right is Professor Andrew Newcomb, Victoria School Law, University. Next to him to the right is Eugene Baikovsky of our law firm, Makalak, Robertson and Sotos. And to the far right is my son, James Makalak, who is our unofficial translator.
Thank you.
Thank you.
On the respondent side, Mr. Smith, please proceed.
Yes, I'm Derek Smith from the law firm of Dewey and LaBeouf, representing the Republic of El Salvador. From the government of El Salvador, we have Benjamin Pletes, who's Secretary General of the Office of the Attorney General of El Salvador. From our law firm, Dewey and LaBeouf, Luis Parada, immediately to my left, Tomas Solis, and Aaron Argueta.
Thank you. According to the notes of the first session, under section 2.2 under B, the point of contact, main point of contact for the respondent is Mr. Luis Parada. I understand, Mr. Smith, that you are here at the hearing, the spokesperson.
I will be the spokesperson at the hearing.
Or the main
yes.
spokesperson, perhaps I should be more correct. Like Mr. Buchalak, you're also the main spokesperson for the claimants.
I will be giving some opening remarks, and then Professor Newcomb will be carrying the bulk of the legal argument.
Okay. Before we get there, we have some more introductory matters. One is that we have an agenda, and the tribunal is grateful to the parties for having agreed to a large extent on the agenda for this hearing of today. There was a small disagreement about the length of time. The tribunal has decided in favor of the longer period so that the parties have a full opportunity to present their case, and we did not want to cut off unduly parties in presenting their case today. The agenda, therefore, is as you have it been distributed. Here we have, let me tell you, that we have first from 9:45 to 11:15 respondents' argument, or so-called initial presentation. Then we have a break from 11:15 to 11:30. We have then thereafter claimants' argument or initial presentation from 11:30 till 1 o'clock. And then from 1 o'clock to 2:30 we have a lunch break. Then there was time reserved from 2:30 to 3 o'clock for the non-disputing parties, the presentations. However, we have been informed that those parties, non-disputing parties, that have made submissions pursuant to Article 1022 will not be present here to make the oral submissions. They have made submissions. We're talking about here Costa Rica and Nicaragua. So the time reserved for the disputing parties will not be used because the understanding is that we have also received a letter from the United States that they do not wish to make comments at this stage, and perhaps the United States could confirm that they have an observer status only. Mr. Kovar, I see that you're nodding, and nodding is not enough for the transcript. Can I say yes on your behalf? Okay, thank you. The United States being an observer only. That means that we can speed up the agenda in the sense that at 2:30 we can start with the respondent's response, the rebuttal. and that will be then to 3:30, and then we have a coffee break of, or tea break for 15 minutes, and then we have claimants' rebuttal at 3:45 until 4:45. Yeah, that's correct. And then after 4:45 till 5:15, we have the final matters. And then we have the conclusion of the hearing. Now, that being the agenda, as usual in an arbitration, just prior to the hearing, you get an increase of correspondence from the parties. And this case was no exception. Tribunal, first of all, is of course liable itself for the increase of correspondence because we asked you for it to do it. We asked you a question last week about the procedure and about discontinuance of Supreme Court proceedings in El Salvador. That was by an email of 9 November 2010. We received, as requested on last Friday, a response from the respondent. Added to that were a day later the two documents referred to in footnote 2 of the submission, the response. There was a small question whether it is admitted to the record. It's self-evident that those documents are admitted in the record because they are referred to in a footnote and should be actually form part of that submission. We have also received a letter from the claimants, which I may quote on 12 November, which says that on November 9, 2010, Mr. Montañez Rumayor related to us that the tribunal invited the parties to answer questions regarding El Salvador Supreme Court procedure. At this time, I'm writing to advise that although we have been addressing these questions, we are at this time unable to furnish the tribunal with our answer. I'm sending this letter so that the tribunal is aware of our efforts and the status of this matter. And with the quote, Mr. Moeschala, would you like to expand on this?
Yes. I apologize. I'm the lead contact, although I'm not Spanish speaking myself, with our counsel in El Salvador. I was in a jury trial till Thursday, which preoccupied my time. I know the people helping me were working on this Tuesday, Wednesday, to Thursday till I completed my other trial. We have been in touch with counsel for El Salvador to try to ferret out an answer to these questions. I don't think that we disagree that the rule quoted by the respondent is the appropriate rule for dismissal where a proceeding can be dismissed. Where we were having difficulty is getting the nuance to the application of the rule. When our experience in courts in El Salvador is nothing happens, sometimes as exactly, experience may be different than the rules. Where our counsel have been telling us that, yes, you can make an application to the court, but you don't know whether that's going to happen in a month, in a year, or what happens. I can tell you today we still do not have although as recently as yesterday, I was in communication with our liaison. I don't have a definitive answer for you today. I think that the rule that they cite is the appropriate rule. I don't have enough experience myself, and I'm having difficulty in communicating how that translates into practical experience in El Salvador.
But let's put it this way. Do the claimants disagree what the respondent has submitted in writing on the 12th of November?
No.
So that's
the rule is they've identified the rule, yes. And I don't question that the Attorney General of El Salvador would miscite an opinion or something. I just don't think that would happen.
So there may be a difference of opinion about the application of the rule, but perhaps we will hear slightly more about this today. Mr. Smith, you would like to comment on this?
Simply that the research that El Salvador has done, and obviously the accompanying opinion of the Attorney General of El Salvador is very clear that a claimant may request termination of the proceedings during the deliberation phase. In the cases we cited in our submission, the time period for a decision between the request of termination and the actual termination has been about 3 months.
Thank you. Then we have no further questions or observations regarding the procedure. The only thing what we would like to mention to you is, since you have, both sides have extensively written on the issue before us, the tribunal would like to ask you questions during the presentation, unless you have an objection to that. Because there are parts which do not like that. Of course, we will let you finish the first sentence.
No objection from El Salvador. I would like to make a request, which is that if the time limits are slightly exceeded in the morning, that the parties be permitted to exceed slightly the time limits and subtract that time from their time limits in the afternoon.
We will apply a reasonable flexibility. Same applies to your side, Mr. Matulak. Then, are there any questions of a procedure or administrative nature you would like to address now or raise now, Mr. Matulak, your side?
Just one point of clarification. Also, since the submission of the written documents, claimants filed claimants exhibits 14 and 15, and just to confirm that those have been entered officially into the record.
Yeah, they have been entered. One second, before you start, Mr. Matulak, I don't see the Secretary of the Tribunal again. There's no connection. Yeah. He has a connection, I don't.
One question, Albert. Where are you going to introduce the delegation?
It's not for the record. There is some, it's not for the record now. No. There are some glitches with the transmission. As you know, this full transparency requires also that it is applied. If you can bear with us a couple of minutes, apparently I'm being advised that they are repairing the glitches in the transmission. So I would invite you, but maximum 5 minutes for pause. Take a cup of coffee or something. Ladies and gentlemen, you cannot go on record here. Yeah, you can go on record. What the tribunal suggests is the following: that we proceed, because otherwise we have to wait probably for eternity before we get the proper connection. But that we have recorded on a video coverage, in a VCR or whatever, or video, and then it is available online later on the ICSID website, if that's an acceptable solution.
El Salvador accepts that solution.
Be fine for the claimants.
And then and hopefully we have then also satisfied the transparency requirements. That's the thing that the tribunal is worrying about.
El Salvador certainly would believe that satisfies the transparency requirements in this circumstance.
Right. What we will do is then we will post this simply on the website of ICSID as a cover and a record of this hearing.
Perhaps it would be helpful if ICSID would post a message on their website now indicating that there's technical difficulties and that's why it's not streaming.
All right.
If that's possible.
But my understanding is that the streaming will be in the air next 10 minutes. But that's
okay.
But that's that's the same. I have to have the same experience as delayed aircraft in the airport. Only 10 minutes more, sir. And 3 hours later, you're still there. So that's the point. But I will ask them as soon as the secretary is back. We'll ask then indeed that they post that on the website.